have a question. I have a buyer who is from Nevada and he's interested in a California dropship e-commerce warehouse business.
Okay.
He doesn't want to go through escrow. I just got off the phone with him where he was arguing with me about, well, if I have my money in there, what risk is the seller taking? Should they drop out? I would rather have my lawyers do all the due diligence. Well, and I was trying to explain to him our process here in California,
Yeah.
and he was kind of arguing with me about it. But I said, I don't set the rules, but this is what protects everybody.
Right. And
Anyway,
Nevada uses escrow companies as well.
uh-huh.
But there are, I mean, I have got a mentee that I'm working with right now who has two buyers trying to buy a business and the real estate, and they, we had a 15-minute argument over whether or not they should be required to provide some type of proof of funds and a pre-qualification letter from a bank saying that the structure they're looking for is acceptable and doable. And they submitted an LOI where they want to tie this guy's business up for 90 to 120 days, and they don't want to provide any financials of their own that show they have any ability to perform. It's like, so there are some buyers that are just, I think what it is right now is, there's these out on the internet, God bless the internet, right? But there are these people out there doing these how to buy a business with no money down and giving these courses and all of that on buying businesses with no money. And so there's people that actually think that, that's what they're going to do. And in some cases, they probably can. In this case, the buyers even went so far as to tell the agent who represents the seller, the business broker that represents the seller, not to talk to the seller anymore. They don't want him talking to the seller anymore because it's interfering with their deal. They want to go direct to the seller. And it's like, well, and they even said, if it wasn't for you, he would have already signed our LOI a long time ago. Well, exactly. But isn't that what we're supposed to do, is protect a seller from having his business tied up for 4 months on some Yahoo that doesn't have any money and can't perform? I mean, come on now. So I don't know.
But in that case, you can entertain other prospective buyers, right? Because they have no money in escrow. So how do you get around?
Well, no, with their LOI, and that's why they wanted an LOI, is they had a standstill provision that would have barred him and barred the agent from talking to anybody for that 4 months, that 3 or 4 months. So we basically said, no, this is California. If you want to do something, we can put together purchase agreements for you. And if you want to lock up the business, you're going to need to put down a good faith deposit to do so. And under a purchase agreement, there's no standstill provision. So the purchase agreement that we use also has a due diligence period for the seller. So buyer gets their due diligence period, but seller gets his as well. So seller can request their financials and request everything. They're asking the seller to carry a note. It's reasonable for the seller to get not only their financials and proof of funds, but also their credit report. And if they refuse to produce it after that, then the seller has the ability to wait it out. And, but if he finds another buyer that's stronger, he can always blow them out of the water and just send them a notice to perform or get lost. So the seller has a lot more flexibility by doing the purchase agreement than they do with the LOI that was being submitted.
How often, or do you ever request a deposit in your LOI?
I try not to do LOIs, honestly. I try to go straight to purchase agreement.
Right to purchase agreement. Okay.
Yeah. And then I try to request a 10% deposit unless the business is over $1 million. So let's say the business is $2.5 million, then the 10% deposit would be $250. We don't necessarily need that much tied up in escrow, but I might have them put 100 or 150 in escrow. So
Hey Tanya, can you open escrow under LOI or do you wait until after a purchase sale agreement has been signed?
you can open escrow under an LOI,
Okay.
but again, then the LOI would need to require a deposit, because if you open escrow, escrow is not going to do anything. They're not going to do UCC searches. They're not going to draft escrow instructions. They're not going to do anything other than give it a number and accept a wire transfer, unless, until they have funds in escrow to pay for things. So, but I think, Miles, you're in Montana, so you guys use closing attorneys, right?
Yes, that is correct.
Yeah, so I mean, I think that it really depends on your LOI, and when there's closing attorneys involved, there are two ways that things get done. So you have an LOI that leads to a definitive purchase agreement, but the purchase agreement still has due diligence periods and other contingencies, conditions to close. Or you have an LOI, everybody works based on that LOI towards a definitive purchase agreement, but the day the definitive purchase agreement is signed is the closing date. So those are two very different things, right? So it just depends on how you're working and what type of LOI has been submitted and what the terms of it are.
So I'm still kind of confused. If we're
Okay.
not going through escrow to hold funds for the seller
Yeah.
or the buyer, how does the deal get transacted? I mean, we're not
So
allowed
you
to.
have a representation agreement with the seller, right?
Yes, correct.
And your representation agreement with the seller, if you used a cab form, because you're in California, right, Ann?
Correct,
Okay. So if you use the cab representation agreement, then it says seller agrees to use a third party independent escrow. So the seller is already obligated to use a third party escrow. So then you just go back to the buyer and say, the seller's obligated to use a third party escrow. I understand you don't want to. The buyer, I mean, the purchase agreement basically says that if the buyer terminates the transaction during due diligence or at any other time prior to release of conditions, that the buyer is going to get their deposit back. So the buyer, has the ability to walk away anytime. But I always try and force the issue. I want everything going through escrow because I want to make sure I get paid. And if all
Yeah,
the
no.
money gets sent to
Yeah,
seller, then maybe the seller decides to send you a wire and maybe not.
right. No,
Um,
I mean, I get that was the underlying things. Like, how do I get paid? But
Exactly. Yeah,
the
escrow is going to protect your fees.
yeah, and then also the seller has no assurances that after all the documents are transferred that, they are going to get a wire transfer or whatever. But what was my question here about escrow is that, yeah, the disbursements of funds has to go through a neutral party, right? I mean, it
Well,
just,
it doesn't have to. I mean, there are situations where businesses, buyer and seller will decide they're not going to use escrow. They don't want the expense or whatever.
Mhm.
And so buyer ends up sending a cashier's check or providing a cashier's check to the seller directly, or sending a wire directly to the seller. But again, you know, it's risky for you as a broker. You want to control the deal, and you basically need to just tell them, both of them, that the contract, even the asset purchase agreement, requires that all funds go through third party escrow.
Right.
What I would do with the buyer is go back and explain to them all the benefits of using escrow, because escrow is there to protect the buyer just as much, or if not more, than the seller.
Well, supposedly he has his own legal quote team to,
Yeah.
do all the liens searches or whatever. I mean, he sounds like a serial entrepreneur that, this is all he does is look for businesses to pick up. in a certain industry. I
Yeah.
just, you know, I- arguing with the buyer about our process is not something I've done before. And
Right.
his argument is, what if the seller decides not to sell after I've invested all this effort? I'm the only one with money in escrow. And then I'm gonna have to pursue the seller for specific performance if the seller decides not to sell after I've done all this work for due diligence and I have money tied up in escrow, whatever,
Yeah.
I mean, they're all valid, but
Right, but so what? What if he does due diligence and all that and doesn't have any money in escrow, and the seller decides not to sell? He's still out whatever it took. Yeah, Cassia.
Yeah, what happens in some jurisdictions where attorneys are allowed to perform as the escrow officer? Could that be what's going on?
yeah, I think so, because he has a team in a different state and I'm not familiar with how they operate. So I asked him to describe his process to me. Which
Well, I think what I've done before, Anne, is I've sent an email to the buyer just saying, okay, well, please ask and send me confirmation that whoever you're using for closing, or that your attorney is going to do your UCC lien searches, get your CDTFA clearance, get your EDD clearance, get clearance from FTV. And attorneys don't do that. They don't even, a lot of attorneys, they wouldn't even know where to start to do that because it's just not what they do every day. So, and then if he does give you that assurance, then maybe what you say is you want a holding escrow set up, um, for the amount of your fee, and there would be an agreement where he's to wire at the end of the transaction, he can wire the seller's portion to the seller, but your fee gets wired directly to you or to a holding escrow or something. But he's right. The buyer is the one coming to the table with the funds. You have a contract with the seller to get paid. But if he's not willing to allow a third party, an independent third party escrow to control the funds and the disbursements, then you're going to have some type of other contract to protect you, to make sure that your fees and your commissions get paid to you, or get dispersed according to your broker instructions or
does the
whatever.
broker have any leverage in that process? I mean, it doesn't sound like it if the fees are being the payments being executed between buyer and seller. And
Well, I mean, I've only had that happen actually once, where it was, yeah, and it was like $1 million something transaction. And the buyers didn't want to use an escrow. I couldn't convince them otherwise. I sent them, all the stuff about clearance and everything else. And ultimately what they did, I ended up having to I had a really good relationship with my seller. And so that's what I had to bank on, was just the relationship with the seller that was going to carry me through. And at the end of the day, she was going to honor her commitment, because they wouldn't, no matter how hard I tried, they were going to just wire all the funds to her, from their attorney to her, actually to her attorney, I think. And then her attorney actually wired the funds to me. So, or she did. I can't even recall. It was so long ago. It's rare. I mean, it does happen. Sometimes you just get people that, they're just doing it their way, period. And then, you do the best you can to convince them to go with your process, because obviously you have a process for a reason. You do it all the time. But if it comes down to making or breaking the deal, then you want the deal to work. You don't want to break it over something like that. So, ask the right questions and cover yourself to make sure that you're protecting, you're letting them know, hey, you need to make arrangements then to do, or your attorney needs to do all the things that escrow would normally do. And that includes doing your UCC searches and getting all of your tax authority releases.
Right.
And if they don't want to do that or don't know how to do that, then we really need to go through escrow.
Okay.